You know that feeling, right, when a letter or a call from a debt collector lands in your life. Your stomach just drops. It's stressful, it feels intimidating, and honestly, you can feel totally cornered. But what if that moment wasn't an endpoint? What if it was the starting point for you to take back control? Well, that's exactly what we're going to break down right now. So, a debt collector has reached out. First thing to know, this is not game over, not even close. You should really think of it as the start of a challenge. And the best part? You've got a rule book and some seriously powerful moves that they are legally required to respect, but are probably hoping you don't know about. And that's the whole point of this. The law actually gives you a specific toolkit to challenge debt collectors. This isn't about just trying to ignore the problem and hope it goes away. No, this is about actively engaging with it, but from a position of power. So, where do you start? What's step one? It's your single most important tool, the debt validation letter. Now, this is not just some simple note you dash off. It's a formal legal document, and it sets the stage for every single thing we're about to cover. Think of this letter as the foundation for your entire strategy. It's the moment where you formally and legally demand that the collector plays by the rules. It is, without a doubt, your most critical first step. All right, let's get into our first core strategy, which is all about making them prove it. We're going to completely shift the dynamic of this whole situation by challenging their fundamental authority to even be contacting you in the first place. And listen, this is absolutely crucial. You do not have to prove you don't owe the debt. The legal burden is 100% on the collection agency to prove they have the right to collect. Until they can do that, you don't have to do anything else. It's all on them. So, how do we make them prove it? Well, the first tool in our kit is a doctrine called successor liability. What this means is that when an agency buys a debt, they don't just get the fun part, the right to collect money. They also inherit all the obligations of the original creditor. You know, things like the terms of your original contract. They are literally stepping into their shoes. And the second tool is called assignee estoppel. This is the legal principle you use to basically say, oh, okay, so you claim you bought this debt? Show me the receipts. It forces the agency, the assignee, to provide the actual paper trail, the documents, showing they legally own the right to collect from you. Okay, let's make this super practical. Imagine you get a notice about an old credit card debt. In your debt validation letter, you're going to explicitly name these doctrines. You're going to demand a copy of the actual purchase or assignment agreement. And you're going to state very clearly that without this proof, the debt cannot be validated, period. Now, this is a perfect example of how powerful specific language is. Using a phrase just like this in your letter completely flips the script. It shows you know your rights, and it transforms what seems like a simple request into a formal legal challenge that they are legally obligated to answer. All right, let's move on to our next major strategy, because this is where it all starts to build. What if you could not just challenge them on their turf, but change the battlefield entirely? This is where the power of compulsory arbitration comes in. It's all about moving the dispute out of the traditional court system. And here's the best part. Most credit agreements already have an arbitration clause hidden in there. So you're not asking for some new right. You are simply enforcing the terms of the contract that they now have to follow, thanks to that whole successor liability thing we just talked about. See how it all connects? And the advantages of doing this are pretty clear. The court system is public, it's often incredibly slow, and it can just drag on and on. Arbitration, on the other hand, is a private, more streamlined process designed specifically for a faster resolution. You're essentially choosing a more efficient, less intimidating battlefield. And once again, the steps are really straightforward. First, you find that clause in your original agreement. It's usually in the fine print. Second, you cite the doctrine of compulsory arbitration right in your debt validation letter. And third, you state very clearly that you intend to resolve this dispute through arbitration, just like both parties originally agreed to. You are taking control of the process. Okay, so we've covered a lot of ground here, I know. Let's just pull it all together and do a quick summary of the powerful legal tools you now have in what we're calling your Debtors Toolkit. Here they are, plain and simple. Successor liability means they have to follow the original rules. Assignee estoppel is your show me the paperwork tool that forces them to prove that they even own the debt. And compulsory arbitration lets you take the whole thing out of court and move it to a faster, more private venue. So here's the main takeaway. Your power in this situation doesn't come from hiding or from ignoring the problem. It comes from understanding these rights. This knowledge is what allows you to flip the script, to challenge the collector's authority, and to take back control of the entire process. And that really just leaves us with one final thought. You are no longer on the defensive. You have the tools, you have the strategies. You're not just reacting anymore. You're ready to act. So the only question left is, what's your next move?